Thanks for joining us for the on-demand version of Live from Relativity Fest 2017. I'm David Horrigan of Relativity, and we're really pleased to bring you this on-demand version of a live presentation we did at Relativity Fest. It's on international law, international e-discovery, and the General Data Protection Regulation. The GDPR takes effect next May, so it's a really timely topic we wanted to bring to you as you prepare to implement the EU regulation that's going to really affect all of your businesses, firms, wherever they may be. Joining me for this presentation are Chris Dale of the eDisclosure Information Project and Meribeth Banaschik of the international firm EY. Thanks for joining us. Let's go back to Chicago.
It's been a successful week, and one of the highlights of it certainly was our panel GDPR, I should say, and beyond. It's our annual international panel. And we've had two people who have been with us before in the international panel, and it's my pleasure to introduce them to you now. First is Meribeth Banaschik of EY. Welcome, Meribeth.
Thank you.
Meribeth is a lawyer with a lot of experience in international data transfers and international e-discovery. She practiced with a German law firm, Newer LLP, before going to EY. She has also done legal work in the banking industry, and she brings a special perspective to us because not only has she worked in Germany with major corporations and major partnerships such as EY, but she's also a licensed British solicitor, and she also is an American lawyer. So welcome, Meribeth. It's good to have you here.
Thanks for having me.
And an old friend is with us as well, a young friend who happens to be a friend of a long period of time. And that is, of course, none other than Chris Dale, founder of the eDisclosure Information Project. Chris Dale is one of the early pioneers of cross-border, I'll say, e-discovery. He was doing this before it became cool. And the eDisclosure Information Project is widely read for information on data transfers, be they in the EU, the US, across the world. Chris, always great to have you.
Thank you, David.
We started off the session. What we thought we'd do in the webinar is let you know some of the things that came up during the session, some of the things we thought were important. But during the registration process, we had some questions come in, and we wanted to address those, and we appreciate you taking the time to send the questions in. Chris Dale, one of those questions was exactly who is covered by the GDPR, or who will be in May of next year, I should say.
Can I start with two contradictions from what you began with?
Yes,
young
please.
Mr. Dale, I don't think it's a very appropriate way of putting it with all its grey hair. And the other, the idea that data transfers of any kind can be cool. Moving on, though, to your question. Effectively, whose data matters, I think, is what it comes down to. Is that right?
Yeah.
It's not citizens' data, as you'll often hear people say. It's not the data of residents of the EU. It's, and I'll read it to get it absolutely right, personal data of data subjects who are in the Union, regardless of whether the processing takes place in the Union or not. You can catch an awful lot of people who aren't in the Union.
Sure.
With that, just looking at email passing to and fro, for example, looking at data being processed where it's most cost-effective to process it instead of locally, you're immediately walking into trouble on that definition, and that's why it's of concern outside the EU.
Excellent. Another question that we had come in was, in the realm of the GDPR, what do we do about dealing with the government? Is that something that you've been hearing from your clients? Are they worried about how they're going to deal with governments and discovery matters after the GDPR?
I know that there have been some discussions about whether GDPR will apply to governments, and a lot of hesitation in how the market would react if they were excluded from the GDPR. I would imagine that regulatory investigations will still take place, and so I don't necessarily know that there's any other exception where they would be exempt.
And regulators will continue to exchange information, not just between agencies, but across borders.
That's
Sure.
right.
And the session was GDPR and beyond, and the reason for the and beyond in that title was, of course, because the GDPR is not occurring in a vacuum. We had the Schrems 1 litigation, which invalidated the safe harbor framework. We're now dealing with the Privacy Shield. And then Schrems 2 comes about. Meribeth, could you tell our audience today a little bit about how Schrems affected what's going on?
Right, this is a drama soap opera that you couldn't even think of your own. And back in 2015 in October, we saw that the safe harbor clauses were invalidated by our good friend Max Schrems, and this essentially sent the business world in panic in how to effectively transfer their data, and not just from company to company, but also within their own group.
Sure.
And this is when the EU and the U.S. started negotiating the EU-U.S. Privacy Shield. But this is also when we saw that Max Schrems was not giving up on his crusade, and then continued to challenge the model clauses, which most companies then sought to use. And this, of course, made it very difficult for companies to have certainty with how to transfer their data, which is, of course, very important. And then, of course, questions up until, I believe it was earlier this month, when the result of the review of the Privacy Shield came out, which it looks to be that it was successful, although there were noted points that implementation needs to be improved in certain manners. And we also know from our past webinars and e-discovery conferences that the Privacy Shield was always based on the Judicial Redress Act, which meant that Europeans needed to have standing in order to sue in the U.S. because this was already reciprocated, where Americans were able to sue in Europe in case there needed to be corrections of data along the way.
You know, I have always found Schrems 2 to be very interesting, and that's basically, of course, Max Schrems' attempt to create American-style class actions in the European Union. And I'd like to ask both of you, we'll start with Chris and then go to you, Meribeth. Do you think there's really any possibility that we're going to have American-style tort lotto with mass class actions across Europe?
Many jurisdictions don't have that concept anyway. It's not a peculiarly American concept, but it's not limited to the US.
Sure.
But
yeah.
We heard from Karen Harty this morning that Ireland, for example, forbids them. I think the most interesting thing about Schrems in this litigation is where the money came from. They were crowdfunded. Yes. And the idea of crowdfunding litigation that is of public interest is actually, I think, much more interesting in a way than mass actions.
Yeah, you know, it was interesting. I went to Max Schrems' website shortly after he started the litigation, and you could actually sign up on the Max Schrems' website to join the class. For those of you European listeners out there who want to join, sorry, the class is full. But I thought, wow, this is an interesting concept. Start a website, get the class. Meribeth, you think it's going to spread in Europe?
I mean, in Germany, we've seen some debates about class actions, and I don't even know that the word class action is the correct word to use in Europe, but more collective proceedings.
Sure. Okay.
And while there's been some debate, I would not imagine that this will, in the near future, be successful. However, we know that under the GDPR, there are possibilities for collective actions to take place. Sure. When represented by a public body who can represent different categories of people to bring actions.
Makes perfect sense. It was interesting. During the session here at Relativity Fest, Chris asked the audience, all right, what's the first thing you think of when you think of GDPR? And sure enough, and Chris, well done setting that up when you knew what the answer would be. And of course, the first thing were the fines. Chris, give us your perspective, if you wouldn't mind, on the importance of fines. We're all obsessed with, oh my gosh, 4% of turnover. For you American listeners, that's just revenue. It's the European term for revenue. But what do you think, Chris? Are the fines as important, or should people be scared?
It's quite interesting to me personally, because my view changed, or rather my view was challenged during the course of the panel.
It was. We always love a good debate.
Yeah, absolutely. And as a result of which, I decided it needed a slightly more subtle description than I gave it originally. The original proposition, and I stand by this, is that too much fuss is being made about the fines, that this is seen as the big headline thing, that people are selling software and services with screaming headlines about fines, that we're back to something equivalent, the Zuberlake idea, that was used by everybody after the Zuberlake action. That, which was very much an outlier, frankly, was used to beat everybody and to say, because Zuberlake got fined, you will.
Chris, I thought you had one of the great lines of Relativity Fest, and I hope you don't mind if I include it in our Best of Relativity Fest that we'll be running on the Relativity blog soon, when you said that the GDPR is the best marketing device since Zubilake.
Absolutely it is. There's points moving in different directions here. One is that if you take the UK Information Commissioner's Office, they investigated 17,300 cases last year. 16 fines resulted from that. So there is no culture of fining by default, and there's nothing in the GDPR that will increase that culture. The fines increase, the circumstances in which you can be fined increase, but the culture of what remedy is the appropriate one is not directly affected by the GDPR. And there's all sorts of other tools which the information commissioners in different jurisdictions can use to encourage people, to prod people, to nudge people in the right direction. There's also things that are very much more punitive in a way than a fine. If your business is processing and your local ICO closes you down by saying you're not to do any more processing until you've remedied this, this and this, that for many businesses would be a great deal more severe as a punishment than any amount of fines.
It's interesting, Chris, that you mentioned processing data. I thought Karen Hardy of McCann Fitzgerald had a great observation when she said historically in Europe, the legal advice was, well, you know what? We're just going to convert you from a controller to a processor, and then you're off the hook. Not so in the world of the GDPR. If you're a processor, you've got some pretty strong requirements. Maribeth, what do you think on the fines?
I think that you could see a trend in the marketing information, for example, on LinkedIn or on the blogs in about a year ago, where fines were the way to get people to take notice. Then you saw a trend up until about maybe 2 months ago where everyone was saying, calm down, we have other ways that we could also help you sort through your data issues, for example, with warnings or the other things that you had mentioned. And I think once we get closer to May 25th, we'll see again a rise in this focus on fines. I think that it was sufficient to get people's attention, but it's certainly not necessarily the key focus. My gut says that perhaps the regulators will wait for the perfect fact pattern of the person who didn't bother to take any efforts or such minimal efforts that it doesn't arise to even a proper plan, and that those might be the people or companies that are then targeted for the high fines.
Yeah. The targets, one of the things that emerged during our discussion this morning, the real targets for the regulators are likely to be the very big people, the Facebooks, the Googles and so on. And you need to have a pretty top level, high level of fines to be any threat at all to somebody of that size. And the reason I think the Zubilake parallel is helpful is that it's an outlier in the same way. The facts of say, Google are extreme.
Right.
And to dictate a whole culture of fear around a weapon that the EU has given itself to attack Facebook and apply that to every passing corporation, big, middle or small, seems to me not to make much sense. I can see why. It does get attention in boardrooms. But can I give you an example of something else that is as likely to get attention? And that's a UK example, TalkTalk. Breach last year, 157,000 sets of personal data lost, including a lot of bank details. And they were fined. They were fined £400,000, so say, I don't know, $450,000.
Right.
Fair amount of money. But they lost 101,000 customers. They incurred direct cost of £60 million and indirect costs of £80 million. And they lost market share of about 5%. You could multiply by 10 that fine of £400,000.
Right, there you go.
And you still haven't scratched the true cost to TalkTalk, even before you get into reputation. Will anybody sign up with them again?
Yeah.
Those sort of questions.
And the reputational damage is, of course, important and also brings in this core accountability aspect of it. Not only do you need to be compliant, but you need to be able to show that you were compliant. Yes. You need to show that you are accountable for yourself and those in your supply chain.
Yes, and reputation goes wider than your suppliers. Do people want to come and work for a company that is that lax about data is one thing.
Sure.
Will anybody employ anybody from the CEO downwards of that company elsewhere if that was their culture, if that was something they let happen?
Chris, you made an interesting point mentioning the size of the company being a factor and who's going to get fined. And a segue in here is when you mentioned Facebook and Google. I shared with the audience one of my favorite Facebook memes, and that is a July 4th American Independence Day thing. It has Queen Elizabeth's picture, and the caption is, "Happy Treason Day, peasants." And I think a lot of Europeans have that view of Americans, especially when it comes to data. We're the wild, wild west. We don't have the historical basis for data privacy that Europe does. Meribeth, do you think an American company might be the first target of the regulators facing the wrath of regulation under the GDPR?
It could be. It could be an American company. I know that most people have the feeling that there are certain American companies that will be targeted. And I think that with the American clients, they have to first figure out, they have to separate out what information they have from European customers. And while they may think that this is maybe a smaller subset of data than a company that's existing solely in Europe, they still have to take precautionary measures to handle that data correctly. And sometimes, even if they play out the business risk, maybe they find that they're also going to be making some voluntary disclosures or sharing information voluntarily beyond what the regulation requires for the reputational risk that's involved.
I'm not going to be drawn on anything that sounds as if I'm criticizing Americans, at least while I'm this side of the airport terminal. And I don't think it's necessary to anyway. Again, the British ICO, which is my usual source because they write in my language, which is helpful.
Sure.
And they're also, I think, quite active compared with some others, has denied that they have a list of suspects, that they're going to be ready to pounce on the first day on a group of companies they've already identified. You can believe that or not as you wish. But if I were them, I would certainly have identified, not necessarily because they're American or whatever, but companies of a class that are potential risks. Companies that keep private data, but not necessarily as their mainstream activity, but nevertheless have a lot of it.
You know, the way that I see this playing out, my personal opinion is, for example, if you have the subject access requests and someone doesn't get a properly, sufficiently informed information about what the data has, they have the option to then notify the supervisory authorities. And in a sense, there will be notifications to the supervisory authorities, thus creating, let's say, a list of complaints. And I think this will prioritize, without them having to do very much, where they need to focus, whether it be on a specific industry, a specific country. I think this will be interesting to see develop.
So the priority for the companies in that position is not to try and achieve everything.
Sure.
And no one's actually expecting them to achieve everything anyway. Certainly, again, the UK ICO has made it clear it's not expecting 100% compliance from 100% of companies, and will be understanding that it's a big task. What it does emphasize, though, your point about subject access requests generating notifications, is that companies might prioritize those things that are going to put their head above the parapet, that are going to draw attention to them. If it's an easy thing to deal with subject access requests rather than risk a notification, well, perhaps that goes up the list compared with other deeper things to do with your data that you might otherwise have thought of as priorities. What keeps our camouflage, what keeps us low on the regulator's radar?
Makes sense.
Would, to me, be a priority.
All right, speaking of that regulator's radar, we've established that chances are it may be a big company. We may or may not relitigate the Battle of Yorktown with the anarchist colonists facing the wrath of European regulators.
You've really got something about this, haven't you?
Well, yeah, because, well, I'll tell you, I'll give the audience some background. First, we had the USA Patriot Act in the U.S. Then we had the Snowden NSA imbroglio, where it was shown that the U.S. government had its hands on a lot of data. What often get lost in the weeds, and we are not really going to relitigate the Battle of Yorktown here, but it was that you, my friend, and your countrymen were knee-deep with us in the NSA, but it was the American vendors who were sort of getting like, watch out, Uncle Sam's going to get your data. And so I think there really is a perception. And at 451 Research, many clients in confidential sessions, they said, you know, you can repeat it, just you can't use our names. But it was like, we are getting beaten up internationally because perception becomes reality and people think, you know, if things go through, and of course that brings us to Microsoft the United States. Of course, since the government's the petitioner, it's now United States v. Microsoft, which will all be confusing with the antitrust action of the same caption. But I think there's a real issue there. And I think, another thing is, we've talked about the size, we've talked about the nationality. What cause of action or what violation may be the one that triggers some fines? And of course, that brings us to the ubiquitous data breach and the 72-hour notification requirement, with also the without undue delay standard. Chris, what do you think about the 72-hour provision? Is it realistic?
It's another useful stick. I want to encourage people to get out there and find out what data they've got and where it is and who's in charge of it and what it contains. The fear of the need to notify within 72 hours is pretty fearsome, and people might adopt the suggestion I made at the end of our session this morning: keep less track and you've got less of a problem.
Excellent.
Delete it.
Good, succinct advice, sir.
Delete it, and then you don't have to worry about it. It's not right to say that every breach must be reported. It's only if it proposes, and this is again I'm quoting, poses a risk to rights and freedoms that it must be reported. The regulators do not wish to be overwhelmed with every, what is a breach anyway? Johnny Lee mentioned this morning that over in the US, you take great care not to use the word breach until you're absolutely sure that that's what you've got.
Exactly.
That doesn't actually help you in Europe, because the definition of a breach is very, very wide and covers everything. And every last laptop left on a train is as much a breach, effectively, as the exfiltration of hundreds of thousands of records. But if it's not a risk to rights and freedoms, then it's not compulsory to, and it will not be. We're talking in the future, of course, talking about the GDPR. It's good practice to report, but it's not compulsory. And the standard, and again I'll quote, it's not an absolute standard, but you ask yourself, what is right for the business and clients of this organization? So thresholds will vary. If you've got medical information or sexual preference information, or so one of those specific categories.
Union membership, for that matter.
Union membership, whatever.
The idea in the United States that whether or not you're a member of a union would be considered personal information is, to an American, it's mind-boggling.
Yeah, but there's a point to finish off here. So there's what is practicable is a consideration, and one of the issues, and you and I have talked about this for years in different contexts, is that Americans like red lines. They like to know, or bright lines, they like to know when they're stepping from being good to being bad, and are uncomfortable with a discretionary standard. That's just one of those sort of cultural things that one gets in ordinary discovery exercises, for example. Whereas most of the rest of us are content to rely on reasonableness and proportionality and discretion, and to reckon that if we do the right thing and behave in a reasonable way, then regulators and courts and whatever will reciprocate. That doesn't always work, of course, but it's a different mindset, and that I think is critical. What the UK regulator wants within 72 hours is to know what's the potential scope of this. Not every last number, but sort of what sort of quantities of people are we talking about here, and what type of data. What was the cause of the breach? One ought to be able to identify, perhaps. But not always. You can't always, but it would be perfectly proper then to go to the regulator and say, frankly, I haven't got a clue. Yeah. We're doing our best. We think it might be this, this, or this. I'll get back to you. That's a better answer than just not answering. Perhaps usually one will be able to identify, because normally you don't find it until you find the finding it and the finding the cause, however late you may be in finding it, may often be at the same time. But the real thing they want is this: how you plan to mitigate the effects and how you plan to address the problem is a much more important thing to get out within 72 hours than every last detail.
Excellent point.
I think that you can see with the 72-hour, I think we're talking about an incident. And I mean, the definition of an incident, it will be interesting to see how this is litigated and what is then determined to be an incident or not. But you start to see patterns. For example, 72 hours to notify for an incident, 30 days to respond to a subject access request. The trend being there's not much time to do that, which means you have to have done your homework before.
Yes.
You have to be ready in order to have the capabilities to answer under that short period of time. And it also brings up the importance of data minimization, because if you've
that's a polite way
not
of saying
collected
keep
it,
less crap.
if you've not collected it, or if you've even anonymized it or pseudonymized it,
Sure.
then what is the effect then? Can someone claim an actual damage if it's been pseudonymized or anonymized? Perhaps that's a way to reduce the effect of a breach.
Yes, that also leads into another
incident.
point, which is, have you planned how you're going to react, what your public face is going to be on any breach that comes along? How are you going to liaise with authorities, with shareholders, with the press? All those sorts of things that have nothing to do with technology.
Communication strategy.
The whole communication strategy,
Right.
that's the right expression indeed. All those things that are quite hard to do while you're flapping.
Yeah.
Because there's an emergency on, the phone lines are burning, and there's headlines against you everywhere you go. So planning.
For example, knowing which supervisory authority to notify.
Is a job.
Yeah, there you go, exactly.
Because if your choice would then be to notify the proper one if you've done your homework before the fact, or perhaps you have to over-notify because you haven't figured out, and so you opt to notify many different. Again, going back to what we talked about earlier, the supervisory authorities being able to collect information on who might not be compliant with GDPR.
Yeah. There's an additional point, very good point Johnny Lee made this morning, is that the authorities themselves are going to be pretty stretched in their resources. They are themselves trying to employ people in competition with the companies.
And then there is a brilliant segue, thank you, sir, and that is, for years now, we've been saying it's a best practice to hire a CISO, a Chief Information Security Officer, or a Chief Data Privacy Officer. Another provision of the GDPR is, of course, the requirement that certain companies have a data protection officer. And it's almost forced compulsory information governance. And I'm wondering, Meribeth, do you think that the companies are actually going to be helped in their management information governance by the hard stick of the regulator?
So I think in Germany, for example, a data protection officer is not a new concept.
Right, sure.
So this, for at least German clients, and I would imagine also for some European companies, is not necessarily a new concept, but for American companies, this would be. And of course, you have to get a feel, and we've done this over the years, of what information, how deep, what involvement do they have to have in certain meetings and certain decisions. And this, of course, friends from across the way can offer some guidance in that. I think what's also interesting is to note that while there are conditions where you're forced to have a DPO, there are also strong suggestions to have to voluntarily agree to have a DPO. And I think that this is probably a good decision, but again, going back to the resource issue, who will you find? Because as soon as you start making a list within your company who could have this position, you realize those people are usually conflicted out because of the decisions that they have to make in their everyday job. Then you're left with some more junior employees or the option to go outside and externally get a DPO.
Yeah, and they're people who have an enormous amount of responsibility without the power to
that's a great point.
To affect things. I wouldn't touch a DPO job. I'd want to be paid a very, very significant sum of money.
As you should be.
To assume that responsibility, that amount of work, all those duties, and probably not have the power to influence things in the way they ought to be influenced.
Excellent. Well, we are almost at the end of our time here. We're going to get some closing thoughts. Meribeth, your closing thoughts and takeaways from today's events.
Yeah, I think that especially to an e-discovery audience, I hear a lot about interviews being conducted in order to establish where your data is. And we know from experience that people don't know where their data is. You can also hear numerous times from clients, we didn't think that we had that kind of data, and we found out that we did. Whether it be employees that are creating their apps without notifying IT, sometimes interviews are a good start, but not necessarily, especially with using eDiscovery core skills, the best way to end. And so that would be my takeaway or advice to our audience.
And Chris, your closing thoughts.
As briefly as possible, the GDPR is giving us the cash incentives, the return on investment for the information governance that we all talked about 3 years ago.
And we're still talking about it. I want to thank all of you for being here. On behalf of April Rumpf, Brendan Ryan, our entire Relativity team across the globe, and our partners and developer partners, thank you so much for being with us, and this has been Live from Relativity Fest.